And the issues that we're going to discuss today go right to the heart of what is compensable time. What is the time that needs to be paid under California law for non-exempt employees? Let me elaborate on that point. The discussion today is going to focus only on those employees that are not exempt from the overtime, minimum wage, record-keeping, meal and rest period requirements, etc. These are the individuals that need to be compensated for all hours worked, and we're not going to, much of what we're going to discuss today will not have application to employees that are exempt from these requirements. I do want to begin today with a discussion about the principles of the law, which I think are really at the heart of the understanding of how courts and the California Labor Commissioner's Office will look at compensable time issues. Then we're going to move into the application and look at various areas in which there's some question about whether it's compensable time: meal and rest periods, travel time, training time, on-call time, and other scenarios. And lastly, I want to spend some time with a fairly recent development out of a case in 2005 called Armenta. Armenta is changed the landscape tremendously based upon the court's conclusion in Armenta as to how you have to pay minimum wage. Bottom line, each hour needs to be separately identified, and the employer under California law must pay an employee at least minimum wage for each hour worked. This is creating significant issues in industries that use commission or piece rate systems to compensate employees, and other scenarios in which employees are paid based upon tasks or services provided and not necessarily paid based upon each specific hour. The heart of wage and hour law begins with the definition of what constitutes hours worked. Now, under federal law, the term hours worked is not defined. It generally has been defined, work has been defined as employ, and employ has been defined to suffer or permit to work. So if you are allowing, as an employer, you're allowing a worker to perform work, you know that that worker is performing work, and of course, if you're directing the worker to perform work, in any of those scenarios, it's going to be compensable time. California has a different law, and as you know, when you're in employment law, you need to comply with both federal law and with state law. And generally speaking, California law is more employee-friendly, more protective of the employee's rights, and it's none more so than the area of hours worked. Under California, hours worked is defined as the time during which the employee is, and this is the key phrase, subject to the control of an employer. And then it goes on to repeat the federal standard, and includes all the time the employee is suffered or permitted to work, whether or not required to do so. The key phrase is subject to the control of the employer. And as we go through the scenarios, you're going to see again and again the analysis turns on whether there is control being exercised by the employer over the employee. To the extent control is being exercised over that employee, there is a greater likelihood that's going to be considered hours worked. Remarkably, there are no cases defining what constitutes subject to the control of the employer. Each one seems to be fact-specific. And this is what is creating, in my opinion, all of the confusion. We're dealing with an imprecise term here, subject to the control. And whereas one judge or one labor commissioner, hearing officer, may see control, another hearing officer, another judge may not see control. And that's why we're not seeing clear, consistent application of these principles. The areas that we are going to touch upon today are, as I had mentioned, meal and rest periods, travel time, which is continues to be a thorny wage and hours worked issue, training time, waiting time, on-call time, and the issues of standby, controlled standby time, and uncontrolled standby time. We'll also talk about activities that are performed by a worker before they begin their primary duties and activities that are completed after they perform their principal activities and whether those constitute hours worked. And we'll touch upon rounding. Now, meal and rest periods. California and federal law differ on meal and rest periods. I'm going to focus today's presentation principally on California law. But typically, under both state and federal law, meal periods do not constitute hours worked and can be excluded from time worked if certain conditions are met. Under the federal law, in order for the meal periods to be not compensable, they must last at least 30 minutes. And that time, the employee must be free from those duties to perform work. There is some federal law that clarifies and confirms that meal periods that are less than 30 minutes, 25 minutes, 10 minutes, etc., those will not be considered to be bona fide meal periods and therefore cannot be excluded from hours worked. None of the time can be excluded for hours worked. So even though an individual may be clearly taking a break for 20 minutes and the meal period is called short, that employee must be paid for all of that 30-minute time or that 20-minute time. California law is similar in that respect. Under meal periods are excluded from hours worked so long as the meal period is at least 30 minutes and the employee is completely free from performing all duty. Those of you who remember the Brinker case, which came out in spring of 2012, the Supreme Court, in determining what constituted a meal period, again returned to the issue of control. And the court in Brinker held that a meal period was provided when an employee had relieved the employee had ceased exercising control over the employee so that the employee was able to take a meal period. The court didn't simply say they needed to make the meal period available. What the court said was that they needed to relieve the employee of a duty to work, and they needed to stop exercising control over the employer. So again and again, you're going to see this principle of control and the exercise of control factor in to wage and hour principles. On-duty meal periods, these are meal periods in which the employer is exercising control over the employee and requiring the employee to work through or to not break for a meal period. In those instances, so long as the employer and the employee have also entered into a on-duty meal period agreement, a written on-duty meal period agreement, and the nature of the duties really does require that that employee work through the meal period. In those instances, that will constitute a meal period. However, because of the control exercised by the employer, it will be compensable time. It will count as hours worked. One principal difference between California and federal law on meal periods, under federal law, you can require the employee to stay on the premises, and even though the employee is relieved of all duty to take the meal period for 30 minutes, it's not compensable time. Not so under California law. Under California law, if you restrict or require the employee to stay on the premises, even though they are entitled to take a 30-minute meal period, that will constitute hours worked, and the employee needs to be paid the entire time. It also, separately, would constitute a failure to provide a meal period because you didn't completely relieve the employee of all duty and completely cease exercising control over the employee. Rest periods do count as hours worked because the principle, well, specifically in California, the regulation and the wage orders do specify that rest periods are hours worked, and so you'd need to pay the employee for the time, even though they are also to be free for at least a net 10-minute period of time to rest. The principles there, again, are the same. The employer still can exercise some control over the employee, and that is why, at its heart, it remains an hours worked situation in which that time counts as compensable time. Travel time. Travel time, as I noted, is a very thorny issue. And there's big differences between federal and state law. And in federal law, there are specific regulations that have resulted from the Federal Portal to Portal Act that exclude certain time engaged in the travel as compensable time. For instance, there is a specific regulation in federal law that says regular home-to-work travel is not compensable. And there's several other regulations that exclude various types of travel time from the definition of compensable time. In California, we do not have any of those types of exclusions. The only thing we have in California is the principle of subject to the control of the employer. That said, case law and has recognized that normal home-to-work travel is not compensable. Normal home-to-work travel from a worker traveling to work and from work to home at the end of the day is not compensable. However, that principle changes, or the answer changes as you look at different facts. If the worker is required to report to a location that is different and further away than their normal commute, that distance or the difference between their normal commute and the commute to that special location does become compensable. Let me give you an example. An employee normally commutes 30 minutes to work, and for a specific period of time, say for instance 2 weeks, the employer is going to require that employee to go to a different location that is an hour away from the employee's home. Under California law, the courts and the Labor Commissioner's office are going to consider that extra time, in my example, that extra 30 minutes that it takes the employee to go to the special location to be hours worked. Why? Because this is now the employer exercising control over that employee beyond their normal commute. That's all fine and well, but let me change the hypothetical, and you can see how this becomes more confusing. If you hire an employee to work at home, and they are going to cyber or telecommute from home, their normal commute is from their bedroom to their desk. They don't have a commute. And so if you have a situation in which you've now decided you're going to require the employee for maybe a 2-week period or a day period to come into the office, in which case they are going to now be commuting 30 minutes. There is an argument that now the employee will be engaged in commute to a special location, even though it's the employer's own shop or own office, and therefore that time will be compensable. Now, how do you deal with that situation? Well, with respect to hiring people and having them work at home or allowing them to cyber commute or telecommute, I think it's important in your policies and procedures to explain that employees will be from time to time expected to come into the office, and that will be part of their normal commute. And that will be a normal expectation. And that may provide some evidence or support that that home-to-work time that may happen from occasion to occasion would be non-compensable time. There is not really much case law on that The cases that are developing, however, are turning on this question of control, and because there are no statutory exclusions under California law, there's just simply this definition of hours worked. The courts, I think, have a great likelihood to find such time to be compensable time. Travel during work hours, between if a worker is going to one location in the morning and then may go to 2 or 3 locations before the end of their workday, all of that intraday time is going to be considered compensable time. That is all time in which the employee is subject to the control of the employer. Traveling away from home. For instance, if you were sending an employee out of state or to a different part of the state for overnight travel, how do you treat that situation? Well, the general principles identified earlier are the ones that normally apply in that situation under California law. In that case, if the employee normally has a 30-minute commute, but in this instance they're going to need to drive an hour to the airport, and then they're going to need to travel for 3 or 4 hours or 2 hours to their location, and then once they reach their location, it's going to take them some time to get to their hotel where they're staying for the night. All of that time from the initiation of their commute to the airport, well, let me clarify. You can exclude their normal commute. So if they normally have a 30-minute commute, but it's going to take them an hour to get to the airport in the morning, you can exclude the 30 minutes, but that additional 30 minutes it takes to get to the airport, all of that is going to be compensable time. That compensable time will include all of the travel time, including any layover time, and all the time until they are at their hotel where they are relieved and free to engage in their own personal pursuits. Some counsel may look at excluding meal periods. There are a couple of labor commissioner email opinion letters that may allow certain meal periods and other periods of rest during the course of the day and travel to be excluded. But I think you need to determine whether you're a risk-adverse or risk-tolerant employer in identifying those situations. To the extent the employee may be stuck in an airport because of their obligation to travel, that employee may very likely have an argument that they're subject to the control of the employer at that time. And because there is no statutory exclusion for some of that time, you're at risk by excluding it as compensable time. One important item, an employer and an employee can agree to a lower or different rate of pay for travel time. That rate needs to, of course, be at least minimum wage. However, as well as the agreement must be reached prior to the employee performing that travel or that service. So you can reduce the travel time rate if you have situations in which travel may be long, but in those situations, all that time needs to be added together for overtime purposes. Now we have some questions. I will see if I can take questions as we go along. I may need to defer some questions to the end to make sure we get through all the materials. The question, how does that work with mileage? Must we pay mileage for the difference in distance to the special location, or is it a total distance that must be reimbursed? That's a question about a separate topic. That is a reimbursement question. And the answer is, well, let me put it in two principles. One, hours worked. You have two questions here. One, is it hours worked? Is it compensable time? The question is, or the answer is, yes, it is hours worked, and it needs to be compensated. With respect to mileage, to the extent an employee is required to incur expenses that are necessary for the job, that employee may be entitled to reimbursement for those costs. The California Labor Commissioner has recognized reimbursement for mileage will satisfy, unless the employee can prove it does not, will satisfy that reimbursement obligation. So the answer to the question is that the employee would be entitled to reimbursement for the extra mileage to that special location. Next question, the travel time you discussed, does this rule apply only to non-exempt employees, or can they be applied to both exempt or non-exempt? Again, the topic is hours worked and compensable time, so that's going to apply only to non-exempt employees. The compensable commute time, can this be paid at a lower rate than the regular rate? Yes, it can. What about flight time? That is compensable time, as I explained, and it can be paid at a lower rate of pay as long as it's minimum wage and it's agreed to before the travel time is performed. How do you handle employees who are field technicians that rarely ever report to the office? In other words, if you have a home office in Los Angeles, but we have an employee that lives in San Diego and leaves from his office in San Diego to customer locations down there every day. That's a very common problem, a common issue, I should say, in which the employer has employees that do not have any fixed location each day, but have alternative job site locations each day. There is no real clear answer to this question. The advice that I recommend is that an employer and employee try and establish a general range or area of the commute, which I think you're fairly safe to say anything within an hour is going to be a normal commute, maybe up to 90 minutes in the Southern California area. Once you're getting up to 2.5 hours as being a normal commute, the facts are really going to dictate that. To the extent it really clearly is a normal commute, you've got stronger arguments. However, I think that the Labor Commissioner's Office and perhaps a court is going to look at commutes of that nature that exceed 90 minutes to now being more than what they would seem to be a reasonable normal commute. And so that's an area of risk. A lot of times I recommend to employers that have alternative sites to stick within a 60 or 90 minute range as a normal commute for employees that have alternative job site locations each day, and to compensate employees at a travel time rate or their regular rate for any time after that. Do overtime rules apply with travel time? Yes, absolutely. What you need to do is you put together all of the time, any productive time worked by the employee plus travel time, all that time needs to be added together, and to the extent the employee is now working more than 8 hours, you will have an overtime situation. What about traveling on the weekend? Under California law, that is also going to be treated under these same principles. They're subject, the employer is exercising control over the employee by having them travel. There are some exclusions under federal law but for that type of travel, but under California law, the normal control principles are going to control. Training time. General attendance at lectures, meetings, training programs, do they constitute compensable time? They do, and they do count as compensable time unless all of the following are met. And we'll talk about two of these in detail. Number one, the attendance is outside of the employee's regular working hours. The attendance is voluntary, and the course of the lecture is not directly related to the employee's job, and the employee does not perform any productive work during his or her attendance. All four of these requirements need to be made in order for you to exclude that time as compensable time. Now, I want to talk about a few of these because they do deserve a little clarity. There are federal regulations that clarify attendance and also some types of programs that may be directly related to an employee's duties. And California law, or the California Labor Commissioner's Office, follows these federal regulations in this limited context. The attendance, first off, the attendance will not be considered voluntary if the employee is led to believe that his or her working conditions or his job is going to be affected if he does not attend, he or she does not attend the training. If, however, an employee on his own initiative attends an independent college or school or trade school after hours for something that's necessary for his job, for instance, if it's necessary for the job that he has CPR training and he attends a college outside or attends a class outside of his office time for that specific thing, even though it's directly related to his job, it will not be considered compensable work. Also, if the employer provides that type of training to their employees, the type of training that's necessary and required for the job, but the type of training that also is available from third-party providers outside of the employer, that time attending that class will not be considered to be will not ruin the exemption for this time. The principle behind it is the employee needs to have that type of training in order to do this job. They can go get it anywhere. The fact that the employer is offering that training should not convert that time into compensable time, so long as all the other elements for exclusion are met. It's important when you're doing these training sessions not to mix it with employer-related type training. If you do have employer-related type training, that will convert that time, and probably all the time, into a compensable time situation. So if you're looking to exclude that time, make sure it's specifically limited to that type of training or course that the worker would be available able to gain from a third-party provider. The old saw about waiting time, engaged to wait or waiting to be engaged. You can hire an employee to wait around in case something happens. You just have to pay the employee for that. Again, it goes back to this principle: you are hiring and exercising control over an employee to wait to do something. That is compensable time. The factor, the focus at this point looks at control, but it also looks at who is benefiting from that type of waiting for work. And to the extent it's for the employer's benefit, it's going to be considered compensable time. The factors that you're going to look at is what control does the employer have over the employee, and can the employee effectively use that time for his or her purposes. This is an imprecise circumstance and an imprecise situation. The more and more you're exercising control over that employee, the more and more it's going to be compensable time. There are several factors that a labor commissioner, hearing officer, or a court will consider in determining whether on-call time is compensable. They're going to look about the required response time. How quickly must the employee respond? The ability to trade on-call shifts. Is the employee the only employee on call, and therefore if they, or is it a situation in which there may be other employees on call, and if employee 1 fails to report, then the request will simply go on to employee 2, and employee 1 will not suffer any consequence. The less and less control, or the more ability that employee has to trade on-call shifts or on-call times, the more likely that's going to be uncontrolled or uncompensable travel or on-call time. Excessive geographic movements. How restricted is the employee? Must they stay within 20 or 30 minutes? There are some cases that hold as short as 30 or 15 minutes is not excessive. I think in Southern California, something that requires an employee to respond within 15 minutes or 30 minutes is most likely going to be perceived by a court to be excessive control, and that may trigger a determination that is compensable time. The employee's ability to engage in personal activities is critical. Can they go on and about their normal personal pursuits? Requiring an employee to refrain from drinking alcohol has not been determined to be so such a sufficient exercise of control to convert an employee's on-call time into compensable time. I think it would weigh in as a factor, but it has not. I have not identified or seen any cases where that has been determinative. The frequency of calls. If there are several on-calls or return calls to require the employee to come back and perform services, the more and more you have of those, the more and more likely it's going to be compensable time, because that employee is going to be less likely to be able to engage in personal pursuits, more likely to have to refrain from engaging in those types of activities and to be ready for work. I should say that these factors are looked at in the totality of the circumstances. And in any situation in which a hearing officer or a judge or a court is looking at multiple factors and applying a totality of the circumstances determination, it really is in the nose of the sniffer, as it were, and some may focus on other factors. Key factors seem to be the frequency of calls and the required response time. One thing that is a great help is the ability for the employee to pass and the on-call, the call to go to another worker. That really strengthens the employer's argument that they're not exercising pervasive control over the employee to create a compensable time situation. Keep these principles in mind as we talk a little later about responding to emails and cell phone calls. These are the same principles that play a role in determining whether responding to emails and cell phone calls constitute compensable time. After hours email and cell phone activity. Couple of questions. Is an employee who checks his smartphone at home entitled to overtime compensation? Again, we're going to be discussing non-exempt employees. If an employee engages in work-related email at home on his own volition, must he be paid for it? Nowadays, with today's technology, employees may be able to get access to their emails through a home computer without even a need to use a cell phone or being provided a BlackBerry. So if you have an employee that is checking their emails at home, even though you do not require it and do not tell them to do that, is that compensable time? Should an employee be compensated for the time he spends updating his professional biography on social media like Facebook or LinkedIn? Does an employee's use of a cell phone after hours constitute hours worked under California law and the Fair Labor Standards Act? All of these questions, again, return to the level of control. They also look at suffer and permit, the suffer and permit component of the definition of hours worked. If you have a non-exempt employee and you have provided that non-exempt employee with a smartphone or a BlackBerry or a device to which they can access their emails, and you require the employees to respond to those emails or answer and respond to cell phone calls, you're setting yourself up for a situation in which you are certainly going to have compensable time issues. Any time that the employee is spent responding to emails or responding to cell phone times are going to be compensable time. The question is, what can you as an employer do about that? You need to have policies in place that spell out what requirements are for the job. And this you have to look at in a number of different levels. It's a strong recommendation for me and I think other employment counsel that for non-exempt employees, you should not provide those employees with cell phones or smartphones with email capabilities and require the employees to monitor and respond to emails and to cell phones. Certainly any time engaged in responding will be compensable time, but to the extent that you are requiring them to monitor or be available to answer and respond to emails and cell phone calls, you're creating a situation of perhaps a controlled standby time. going back to some of the factors we looked at before. I want to talk a little bit about this case, Rudy versus Lojack, which is a federal court decision, but it, I think, identifies clearly, or not so clearly, but starkly how these issues are now affecting employers in the workplace. In this situation, you had an employee technician that installed LoJack devices on automobiles. And like the question earlier, the employee went to different locations each day to do the installation of the LoJack device. In the morning, the employee was required to go online and download the various locations for the workday. And then they needed to map out the routes that they would take for those various locations in the day. Then they would drive in an employer-provided vehicle. And the employer had some restrictions on that employer-provided vehicle. They said that the employee could not carry any passengers. There were no personal errands that were allowed in that company vehicle, couldn't use cell phones, and that the employees must drive directly to the first job and then at the end of the day directly from that last job to home, and they couldn't take detours. Once the employee arrived at home, they were required to upload various information from the course of their workday on a computer-provided, an employer-provided device. And the question in the case, whether all of this time was compensable under federal or state law. And you had three components. You had the activities that were before their workday began, the commute to the workday and all that intraday travel, and then the activities once they returned to work at the end of the day. And the court issued several different opinions and concurrences and dissents in deciding this issue. Let's take a look at what the court held. The court held that this morning preliminary activity of doing the downloading and doing all that activity were related to the employee's commute. And they found that that was not compensable under the state law because it was excluded as not directly related to their principal activity. It fell within the exclusion. And there was also a question that it appeared to be de minimis time. So therefore, it was not compensable time. The court looked at under California law and specifically on the commute. The commute under the federal court, under federal law, the court said the commute was not compensable time. Interestingly, though, under California law, even though this was home-to-work travel, the court concluded that this was likely compensable under California law because of the control that was exercised over the employee. Specifically, the employee needed to drive directly to the job site and was not permitted to take up passengers, not permitted to detour. And the court concluded that was the exercise of control. So here you have a situation of just normal home-to-work travel in which a federal court concluded that to be compensable time. They also looked at the time at the end of the day. And the end of the day was where the employee was required to upload data. The court said that they weren't certain how this how they would rule on this, and they sent it back to the trial court on the basis that it may be compensable time, but it may be de minimis. And we'll talk in a minute about the de minimis exemption. But you see in this situation, in this one case, where the principles of control applied in such a way that each of these times where there was a great risk, it could have been found to be compensable time. Uncontrolled time does not count as hours worked. The employee must be unrestricted to use his or her time for his own purposes. The requirement that an employee keep a cell phone or pager does not require that an employee be paid for all those hours. However, depending on how much control you're exercising over that employee in responding to emails and responding to cell phones, you may get yourself in a situation in which it does become compensable time. And again, we look at those factors for controlled time, the frequency of the calls, a fixed time for a response. Could they easily trade on-call responsibilities? Those factors are the same factors that are going to apply in determining whether an employee is engaged in performing compensable time that needs to be compensated. I do understand we have some questions. I'm going to keep moving, and we'll try and get back to those questions as we get to the conclusion of the presentation. Response pay and de minimis principles. The employee must be paid for all time spent responding to a cell phone or reviewing or responding to email. The same principles apply if you direct an employee to go dig a ditch or perform some service. That's compensable time. Same principle applies here. If you require them to respond to an email and they do, it's compensable time. Now, there is under federal and state law a principle of an exclusion of what is considered to be de minimis time. And there's a number of factors that are considered to determine whether time is de minimis. And if it is considered to be de minimis, it does not need to be paid and does not constitute hours worked. And those factors are, first, is there a practical administrative difficulty of recording the additional time? Now, understand that the principles of de minimis emerged during a period where people were using time clocks or handwriting their time. Nowadays, with the advent of computerized timekeeping mechanisms, plus the fact any email response is going to have a date and time affixed to it, the administrative difficulty of recording the additional time is much, much lessened now than it may have been in the past. The aggregate amount of compensable time. Is there on a daily basis, is there a number of minutes that an employee is engaged in this otherwise compensable activities? The larger the amount of time and the frequency of that, the increased likely that you're not going to be able to take advantage of the de minimis exemption to exclude such time for compensable time. And again, you look at the regularity of that additional time. Does it happen each day? If it does happen each day, how much is happening each day? So this is an area in which there is a de minimis exception, but if you're requiring employees to respond and carry cell phones and respond for emails or respond to cell phone calls, you most likely are not going to be able to rely on the de minimis exception because you're not going to be able to satisfy the factors. A couple of tips with respect to after-hours email and cell phone activity. You need to implement a policy, and we recommend a written policy prohibiting off-the-clock work by non-exempt employees. You need to also enforce that policy. You should restrict company-owned devices to exempt employees whenever possible. If you're providing these devices to non-exempt employees, you're courting trouble. Train your supervisors to never request that non-exempt employees work off the clock or respond to emails off the clock or after hours. It's important that this policy be implemented at each level. Not only are you addressing employees, but the supervisors need to know as well that when they send an email to a non-exempt employee and expect that employee to respond, that's going to be a compensable activity. You should prevent employees' access to emails after hours, and certainly have policies restricting them from the use of emails. There is a principle of law in wage and hour law that if the employee is hiding the work that they're performing for the employer, that the employer does not need to pay for that, even if it is being performed on behalf or for the employer. That's not so easy to rely upon when you're talking about emails and cell phone calls, because you frankly have a record that the employee was now performing non-exempt work or email or performing after-hours activity, and you may be clearly benefiting from it to the extent that they're responding or answering customer or supervisor questions. And so I wouldn't rely on that exclusion. Let's talk about the Armenta rule. The Armenta rule is Armenta is a significant case that came out in 2005, and it significantly changes how wage and hour law applies in California. Under federal law, the federal law allows an employer to average an employee's total weekly compensation across all the earnings in that work week to determine if the federal obligation is met. So, for instance, you just simply add all the hours worked, divide by the minimum wage, or divide the earnings by all the hours worked, and so long as the employee is making at least the minimum wage, you've complied with federal law. That is not the case with California law. In the case of Armenta, the California court held that employers must pay at least the minimum wage, which in California is $8 an hour, for each hour worked, and may not use the averaging method permitted under the Fair Labor Standards Act. The facts in Armenta are significant. In Armenta, it was a union employer, and the union employer installed telephone poles. And under the collective bargaining agreement, the agreement specified certain production hours in which the employee would be paid their rate of pay under the collective bargaining agreement, which was very high, certainly higher than minimum wage. However, the agreement also excluded certain work as not productive work, as work that the employee would not be paid. And this was certain prep work and other types of activities. The employees sued, saying that they were not paid minimum wage for this excluded non-productive work. And the employer attempted to defend the claim by saying, well, you just need to use this averaging principle under the Fair Labor Standards Act to determine whether, when you look at the total compensation by the employee, were they paid the required minimum wage. And the court rejected that defense presented by the employer and said, no, under California law, you need to look at each hour individually to determine whether the employee was paid at least minimum wage for that hour worked. Well, in that situation, that seems to make sense. What has happened, though, is that this has been applied to other industries. And you can see the slide on there just to reemphasize that California employers must be able to establish that its employees were compensated for each hour worked at no less than the state minimum wage. Where this is having impact, however, is on piecework and commission compensation plans, where an employee may not necessarily be compensated for each hour worked, but is being paid based upon how many pieces the employee makes or a commission. Now, it's very important to understand that it's always been the case in California law that non-exempt employees that are paid by piece and that are paid by commission are still entitled to be paid the minimum wage. And normally, the way that this has been interpreted historically by California courts and the Labor Commissioner is you need to take the total hours worked and the total earnings, whether by piece or by commission, and determine for each hour worked whether they were paid at least the minimum wage. You could use the averaging method for piece and commission type workers. And if there was a shortfall, employees were obligated to make up that shortfall so that minimum wage was guaranteed for all hours worked. The problem is that there are several industries, and I'm going to highlight two, the trucking industry and the car dealership industry, in which the employees are being paid on a piece rate basis, and that piece rate may not compensate the employee for all the hours worked. There are a couple of cases that have come out since 2009 on this issue. In the Cardenas case, dealt with a trucking company who paid its employees by a piece rate formula. It was based upon the number of products delivered or number of miles driven. But it didn't compensate employees separately for requirements and duties that they had to perform before, pre-drive check duties that they had to provide before they started the truck, as well as post-shift duties at the conclusion of their shift. And the court concluded that those pre- and post-shift duties were not compensated, that there had been no compensation for those periods of time under the piece rate system, and the employees were entitled to minimum wage under the Armenta rule for that time, and you created a minimum wage situation. The same scenario has happened with car dealers. Car dealers pay their mechanics on a piece rate system that is based upon the task performed. So, for instance, if they are performing a brake replacement job, they are paid for the 2 hours that it requires to do that it is scheduled to do that brake replacement. And they are not paid for any time where they may be waiting, any downtime between performing these services. The court concluded in the Ontiveros case that that time spent, that downtime spent, was not compensated through this flagged compensation system, the piece rate system, and the employee was therefore entitled to additional minimum wages for that period of time, spending downtime. On the Conway case, you had the same scenario with the trucking company as well as the Snyder Logistics case. The other areas that we are seeing this is with other employees that are being paid commissions. For example, massage techs and spas and other industries that earn a commission. That massage tech may be required to begin work at 9 o'clock and is paid a commission for each service that they provide. But during the course of an 8-hour day, they may provide six hours of service, and they're getting paid maybe 20% of the charge, which is a high commission. But for 2 of those hours, if each service they're providing is 1 hour, for 2 of those hours they're not earning anything, even though they're subject to the control of the employer. And the courts are concluding that there is a minimum wage violation there. Now, lastly, there was a case that came down, and these are all trial court decisions. They're not appellate court decisions. That came down at the end of 2012 dealing with Nordstrom's employees. And these employees were compensated at minimum wage and commission, but they weren't compensated for all non-commission producing type of duties. There were certain stocking duties and pre-opening and post-closing duties that they weren't paid minimum wage. And the employer argued that this was time that should have been compensated and covered by the commission agreement. And the court in Nordstrom rejected the employer's argument and noted that during those stocking times, as well as during the times before opening and after closing, the employee was not able to earn. And since they were not able to earn, that time could not be considered compensable time. And I think that that's where the courts are ultimately going to end up going on this, whether the duties that are being performed are part of the duties that go directly to the earning of the piece or earning of the commission. So what is the takeaway? If you're an employer and you're paying an employee by piece or you're paying an employee by commissions, you need to make sure that that commission or that piece rate pay plan is clearly described to the worker to include broadly all the duties that apply and that are necessary to be performed in order to earn that piece and commission. If you have certain types of duties that are not related, for example, meetings or other types of paperwork duties that may not be related to that worker's opportunity to earn a piece or a commission, the employee almost certainly is going to be entitled to be paid at least minimum wage for that time. It needs to be segregated, and it needs to be recorded. There is a case that is now in front of a California Court of Appeals. It involves downtown LA Motors, which is going off of these car dealer mechanic flagged hours issue. A decision is expected before or in early April of 2013. This will be the first California Court of Appeal decision to deal with the application of Armenta to a piece rate system. So I think you need to stay tuned. This is going to be a very, very important decision, and I think will go a long way to clarifying the extent to which an employer must compensate employees for these additional time spent under piece or commission rate systems. Time records, it's important under California wage and hour law to record all time. It's a requirement of the Labor Code. You need to include all time, including when time starts and when time ceases. It's the days of just recording 8, 8, 8, 8, 8 are over. You need to show all the hours worked. Employees must be furnished wage statements. Among the requirements in the wage statements, as you see in number 2, you must have the total hours worked. In number 3, of course, the number of piece rates earned and any applicable piece rate. The total hours worked issue is the one that you need to keep your eye on. There are the additional requirements for the itemized wage statements. So what happens if you don't provide an itemized wage statement, or if the wage statement is inaccurate? For instance, it doesn't include all the hours worked. Well, the labor provides that an employee suffering an injury is entitled to recover damages or penalties up to $4,000 per pay period. Well, effective this year, January 1 this year, the Labor Code was clarified to define injury as occurring if the employer fails to provide a wage statement, or, and this is what is important, the employer fails to provide a wage statement that contains accurate and complete information and that is not promptly and easily understandable regarding the specific item. Well, in this case, the issue is going to be hours worked. If you're not including all the hours worked, including all of the compensable travel time, compensable meal period time, compensable training time, you're going to now have a check stub violation that may give rise to an injury claim by the worker for damages and penalties. The common problem with the itemized wage statement is it fails to show all the rates of pay and the corresponding hours worked. Other problems is they show the same hours worked for each pay period regardless of the number of hours worked. For example, employees that are paid twice a month for the first 15 days and from the 16th to the last day. Those non-exempt employees may be paid. I've seen many timesheets that show, or pay stubs that show 86.66 hours, which is the mathematical figuration for the total earnings based upon a full year. Well, the truth is that that employee is not really 86.66 hours in that pay period, and so you have an obvious and clear violation of the itemized wage statement. So it's important that all of the wage statements correctly reflect the actual hours worked. There are several strategies for preventing off-the-clock climbs. You need to be familiar with these laws. You need to pay for all hours worked and pay the proper rate. It's important to go back, check your policies, particularly your cell phone policy, your off-the-clock and travel time policies, to ensure you're in compliance with California law. If you pay by piece or commission, make sure that you have broadly and clearly defined the duties that go into that pay or commission. Investigate all complaints. Enforce the rules. You need to make sure you train your supervisors, and of course, speak with your lawyer. Make sure you understand these changing requirements. Tuned on that case involving Armenta, involving Downtown Motors. It will be I think, a game changer and go a long way to clarifying the requirements for the law. I think I've come to the conclusion of my time, and so I won't be able to answer these questions. I believe Nicole will respond on how questions can be addressed. Thank you.